The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, judges and lawyers, and welcome to the Court of Appeals in a Zoom fashion, but nonetheless the Court of Appeals. And I hope you can see all of the judges here. It's Judge Harris and Judge Rushing and myself. And we're now ready to proceed, and we will proceed in the same manner as we would as though we were right in front of each other. And we'll start out with the appellant in this case. Mr. Smith, are you prepared to present your case? But I think you need to unmute yourself.
Yes, Your Honor, I am.
Proceed.
Thank you. Good morning. May it please the court. Josh Smith here on behalf of the appellant, ClearTouch Interactive, Inc. I'd like to start with and focus my limited time as best possible on what we think is the most important issue before this court and the res judicata issue. But of course, I welcome the court's questions and concerns you may have on that issue and anything else, because that's what we're here to do today, is address those items. The last minute sua sponte reversal of the court's res judicata decision on the eve of trial was affected by multiple legal errors and resulted in undue prejudice to ClearTouch. After the res judicata argument had been denied 3 separate times by 2 different federal judges, the court, 6 days before trial, reversed itself sua sponte, citing what it called new evidence and saying it was correcting clear error and passing without identifying any. There are 3 independent legal errors with that ruling. First, it violated Rule 54B. There was no new evidence presented at all. The evidence that the court cited as new was the 30B6 deposition testimony of ClearTouch Interactive. Well, Oakers had already submitted the affidavit, or the declaration rather, of John Hauser in support of its summary judgment motion that purported to summarize that testimony about what ClearTouch knew concerning the use of the touch view marks, which are the infringing marks in this case, before signing the settlement agreement in 2021. And if you look at, that's Joint Exhibit 1047 in paragraph 5 is the pertinent paragraph of Mr. Hauser's declaration we're discussing. And that summation purports to say that the ClearTouch testimony.
So one initial question, at least in terms of how we characterize what was submitted, you say new evidence, but isn't it standard different evidence?
The case law and everything we see, Your Honor, is new evidence. But if it is different, it's not.
Which case do you say indicates that it's new evidence and not different evidence?
Oh, the ones we cited for the standard, Your Honor, and I don't have that particular one.
You can bring it back when you come back. That's okay. Go ahead and proceed.
Oh, thank you, and I will do that. But to your question, though, okay, let's talk about it being different evidence. Well, it's not different either, whether we call it new or different, because the summation of the deposition testimony that the court called new evidence says that ClearTouch admitted in its depositions that it had representatives at a 2019 trade show where Ockers first presented products, brochures, etc., with what they call the Ockers marks, touch view marks, and said that we knew that ClearTouch knew about Ockers' use of those marks in 2019. Well, that's not what the deposition testimony submitted on the 26th of November 2024 to the court said. All it said, and ClearTouch's testimony was, all it knew in 2019 was that Ockers had a house brand name TouchView and that TouchView had a website. So the summation in Mr. Hauser's declaration of that testimony is more favorable to the res judicata argument, and importantly, Ockers decided to submit that instead of the deposition testimony that it had in its possession and could have submitted in the summary judgment motions practice. They chose not to.
Can I ask you just maybe step back a teeny bit and sort of address a concern I have about this argument? And maybe it's sort of institutionally driven, sort of given kind of my job. Like putting to one side, I guess, some of if you think the district court was wrong the first time and right the second time on the merits of the res judicata issue, why would we adopt a standard that makes it almost impossible for the district court to correct that error before a whole trial goes forward and then we have to reverse it on appeal? Do you see what I'm saying? Like, just as an institutional matter, don't we want district courts to sort of get it right the first time? And why would we have a standard that makes that especially difficult? And I am struck by the fact that it's not the change here was first a denial of summary judgment. And it's just not obvious to me that when a district court basically doesn't do anything, doesn't grant summary judgment, that we should treat that like a law of the case decision where there's a very high threshold before a district court can actually just change its mind and say, wait a minute, let me get this right before the trial starts. That's my practical concern.
And it's absolutely valid one, Your Honor. And that's why, the Rule 54 is about finality, we believe. And we recognize that it does give the district court discretion to go back and try to correct things if things were wrong.
But all the district court did the first time was nothing. Decline to grant summary judgment. That seems slightly different to me. Like,
yes, Your Honor.
Finality.
Oh, sorry, I didn't mean to talk.
No, I'm sorry. You're not cutting me off. Go ahead.
Okay. Well, it's different in this particular context, these unique circumstances here. The denial of summary judgment in this case was a legal decision because it resolved a legal issue. It just resolved it against Oakers and in our favor for the third time. So it was one that we reasonably and understandably relied upon in moving forward, preparing our case for the next 3 weeks before we're supposed to start a 2-week trial on a complicated matter. So, and this makes me think of one of the cases that my opponent cites in their response briefs going to this very issue, Your Honor, says, look, denial of summary judgment is not beholden to the law of the case. Well, the next sentence after that, one quoted in that case, says that's because it doesn't decide a legal issue. Well, here we think a legal issue was absolutely decided on November 6th when the res judicata argument was denied. And that's why we argue it is beholden to the law of the case doctrine. It's set.
But you don't disagree that Rule 54B is not about final judgments. It does allow the judge to change his mind before the judgment. That is, you agree to that, don't you?
I agree it's not a final judgment, Your Honor, absolutely. But also,
and do you also agree that it allows the judge to change his or her mind before the final judgment?
I do, but it's not without the limitations set forth in the rule and the case law interpreting it, as we briefed in our written submissions to the court.
Well, if you think about this, Judge, and it's either you can seek to say, well, he's just wrong, or it could be rather admirable what this judge did. He could have just let this go on through trial and then bring it up at the end of a full trial. And he says that's not fair to the parties. And he just happened to, I think the point overall is that he reviewed this evidence, realized that Clear Touch knew about the potentially infringing marks at the time of the settlement agreement. That seems to be what he came to a conclusion of. And in recognizing that, he, forthrightly, look, you can go through this trial, but there's going to be a determination at the end of it that's going to go in this way. It seems awfully unfair to have that in your head and not come forth with it at that point with it and handle it in the manner he did. Many judges probably would have just let it go. You got a jury, everything's all set, but why do that if you know this already? And again, I don't know if it's new evidence. It was what you would call different evidence, which I'm pretty clear that's what the case law is. But if you find something different, I'm interested to hear that.
Yes, Your Honor. And when I have a moment, when Mr. English speaks, we're definitely going to look at that. But like I said a moment ago, we contend it is not different evidence. Mr. Hauser's declaration purported to characterize the relevant testimony from Clear Touch's 30B6 deposition. So it's nothing different. It's nothing new. It's nothing different. It's what was before the court when they made when Judge McDonald made his decision on November 6th that was in line with Judge Kane's prior two decisions on the res judicata issue. So that's why the limitation of Rule 54 comes in. Yes, we wholeheartedly agree. The court can go back and alter prior decisions, but it has to do it within the constraints of the rules and the law interpreting them. And again, I go back and I know I said this a moment ago, but we think it is subject to the law of the case doctrine, given the particular circumstances of this order.
But you don't need new and or different evidence under the law of the case doctrine, even assuming this is the standard. It's enough if it's clear error, right?
Your Honor, yes, clear error,
I'm
obviously.
not sure why we're, yeah.
Clear error is another ground, obviously, on which they can go back and change their prior decision. But as we cited, I think it's the TWFS case, you know, clear error has to be something patently obvious, has to, quote, smack you in the face with a stink of a 5-day-old dead fish, I think is the quote, or something along those lines. So it has to be readily and incredibly apparent. What we have here is a res judicata decision that was made 3 times by 2 different judges in our favor and then reversed on November 26th. I contend that if 2 learned federal judges make the same decision 3 times and then it's later reversed, that's not clear error. And if you look at the court's November 26th order, the res judicata order, as we've been calling it in our briefing, it doesn't explain why it's clear error or identify any. It just says it in passing. It really focuses on, it calls it new evidence, and plants its flag on that deposition testimony as a basis for the reversal.
So when you're looking at the clear error, I think what happened quite a bit, and it seems like me, is a question of you got a release and a dismissal. Isn't that language different with the release and the dismissal here?
You're on a state court dismissal, Your Honor?
I'm talking about the language that's under consideration here, whether there's a release or whether there is a dismissal. I'm saying there's a separate release and then there's a dismissal language there. Isn't that language different?
The state court release order that I believe you're talking about incorporates what, if you look at the settlement agreement, the substantive settlement agreement between the parties.
I'm talking about the release under the settlement agreement. There's a release there. Right?
Yes, sir.
And then separately, there's a dismissal language there.
Yes.
Those are different. That is different, is it not?
No, in the settlement agreement, Your Honor, yeah, I think you're talking about the paragraph 3.
Right in front of you. That's right. Paragraph 3, right in front of you. That's what I'm talking about. What I hope you're talking about. I'm saying, is that language not different? Paragraph 3, paragraph 4 of the settlement agreement, is that not different language?
There's different language in those 2 paragraphs, Your Honor. Yes.
Yes. And I think it's important to understand that, because you could conflate the 2 and call it all just a release, but you really have a release and a dismissal.
All right, and we think the release language, looking at all these different parts of this settlement, because you got the memorandum of agreement from the mediation as well, and the handwritten language there, and then the 2 things Your Honor just mentioned. We think the most and best place to look to try to derive the intent of the parties, as the court was required to do in doing this, is looking at the release language first and foremost. That is the most full and substantive recitation of what the parties intended to release one another from.
Well, the intent you can get to, but if you got the plain language there in front of you of what that release says and what that's dismissal with it, do we really need to get into what you intended? It's right there in front of us.
I understand the court's position on that. The court below got into the intent heavily.
Not necessarily a position, it's a question.
Yes, sir.
Don't take it like I'm making my mind. I'm asking you a question to help me to understand it. And the point being, I think at times even the court, might have called something that's a release, but instead you've got this dismissal language that's clearly, in my opinion, separate language. And this isn't about the release, and that's the kind of error that the court might have made. I don't know, but this is about the dismissal of this case.
I understand.
That's the question of, do you agree?
I agree. The language in those two paragraphs you reference are different. Absolutely.
But the question goes further. It's,
Okay.
in other words, is this case about that release or is it about the dismissal? And I'm saying it's about the dismissal of the case.
I got you, Your Honor. We contend it's about the release. As I may not have said it as clearly as I meant to a moment ago.
So what do? Ignore the dismissal language?
I don't think you ignore it. I think you look at the release, and that defines the scope of what the parties released. And you also can look at, because it incorporates the memorandum of agreement from mediation. And that release, as that language reflects, that's JA 202, is in line with the release language.
Well, see, that's what I think is the heart of this case. And if there's a difference of opinion on it, it may be there. That dismissal language is broader. Would you not agree?
The dismissal language, it's broader than the release language. Yes, Your Honor.
Yes. And so there's no dispute that isn't covered by the release. So the question that comes to mind is, if you say you're relying on a release and you got dismissal language that's broader, seems like the dismissal language is the controlling language that's here. That's what the district court said. It said this is about dismissal.
I understand what Your Honor's saying. I don't know if I agree with your characterization of the district court's order. I think they looked at everything. They went outside the four corners of this agreement. They talked about Judge Addy's, the state court judge's commentary and the motion.
That's fair enough. I'll tell you what, you got some time in rebuttal, reflect on it. And if maybe you can get your answer together. I don't want to put you, it sounds like I'm giving you a question that you really hadn't thought through enough to articulate the answer you want to give. And I'm going to give you a little time to do it. And then, of course, I'd like to hear from Mr. English on it, too. So, judges, do you have any further questions of Mr. Smith before we proceed to hear from Mr. English? All right, Mr. Smith, we will come back. Looks like you got some time in rebuttal. We'll be hearing from you again. Mr. English, we would like to hear your presentation.
Thank you, Your Honor. May it please the court. I'm Greg English. With me in the room is Jimmy Cox. We're with the White's Law Firm in Greenville, South Carolina, and represent the appellees. In its appeal, ClearTouch asked this court to overturn both the trial courts and the jury's enforcement of ClearTouch's settlement agreement with the appellees so that it can continue to pursue and harm a competitor through ongoing litigation. In pursuit of its goal, ClearTouch raises 6 issues in which it attempts to conflate legally distinct entities, conflate contractual provisions, and conflate legal doctrines. But none of its arguments warrant overturning the jury in the trial court. And specifically on the res judicata issue is where you see the conflation, and I think the court has already picked up on that.
What are you saying they're conflating? Because it is the res judicata issue that Mr. Smith focused on in his argument. We do have the briefs on the other issues there, so unless the judges choose to delve into them, let's focus on what he has argued here. But of course, if you want to have further commentary, do it. But so when you say conflation, what are you talking about?
I'm saying Mr. Smith is conflating the release with the dismissal language. And
can I ask you about that?
Yes.
We have to obviously read the entire agreement, and there's language in the release and potentially broader language in the supposed dismissal. I'm still a little confused how you dismiss claims that aren't brought, but that's what the parties did, right? Claims that were brought or could have been brought, counterclaims that could have been brought. What in the release language or the dismissal language, what in any of that language releases future claims that could not have been brought today but could be brought in the future? What language do you think does that?
Your Honor, I think that's the language in the dismissal that says, and remember that we specifically added that language that, and we hand wrote it into the first settlement agreement, that it would be a dismissal with prejudice of all possible claims and counterclaims. And that invokes the doctrine of res judicata and the case law that interprets the scope of res judicata.
But there's no you can't point me to any specific language saying claims that may hereinafter arise, right, future claims. Some contracts say claims that a party now has or hereafter may have. There's no language like that, is there?
There's not any language that would preclude, for example, if Oakers had, after the settlement agreement, say, started to use the Clear Touch mark as opposed to using its own TouchView mark that the Patent and Trademark Office had registered. So if the Oakers defendants had done something new and different, then that would not be precluded. But what was
Do you agree that each use of a trademark, each infringing use is a new claim?
not exactly the way the Clear Touch has phrased it. And there are cases that address that specific point that we cite in our brief.
Yeah, and doesn't the Lyons case say the statute of limitations doesn't accrue for a trademark infringement claim until the trademark is used? There's an infringing use?
You're right that the Lyons case involves the statute of limitations, and what it holds is that a plaintiff's failure to include claims beyond the statute of limitation do not preclude a plaintiff's pursuing claims within the statute of limitation. But the cases that we cite, and the Paragon case cites a Fourth Circuit case, the Harnett case, that defines the scope of res judicata as including claims that are part of a transaction or a connected series of transactions. And that's why it's so important to realize that ClearTouch knew when it removed this case to federal court and refused to agree to remand that it had federal intellectual property counterclaims because it had known for 2 years prior to the settlement agreement that Oakers had been using the mark TouchView Interactive. And so that's why it threatened to sue. And
I guess I'm a little, I'll tell you what's bothering me is that, in these settlements, the plaintiffs knew that they had an infringement claim because they knew that this mark was being used. And it looks like your clients are agreeing that they continued using the mark in the same way before and after the settlement. I think that's in your brief. And so in the settlement, the parties could agree in their back and forth negotiations, they could decide, we're going to require the defendants to agree not to use this mark going forward, right? Or they could instead agree, we won't sue you about this mark ever, right? And we're going to allow you to use it. We're going to agree that it's not infringing in exchange for whatever it is you're giving us. But instead, the parties agreed to resolve all claims they could have brought as of today, right? Claims that were brought or could have been brought as of the date of settlement. And that leaves me thinking there wasn't a resolution about who has the right to use this mark. And instead, they agreed, we're not going to sue you on what we know today, but we're not foreclosing the possibility that we might sue you for infringing uses in the future. The district court seemed to say, well, you could get an injunction that would prevent future infringement, but the release and the dismissal talks about claims, that we're releasing or dismissing claims, not that we could prevent future claims by getting some sort of remedy, right? And we're giving that up. So what do I do with that?
Well, and I think you make an important point. They cite the Dewberry case as an example, and Dewberry is distinguishable because there, the holder of the mark had very detailed provisions in the settlement agreement about what uses were and were not allowed of that mark. Here, we came to this mediation with ClearTouch already having threatened federal intellectual property counterclaims, but not yet having answered the state court case. And of course, trademark claims, state courts have concurrent jurisdiction of those. So we knew those claims were there. And the way we addressed that is with very broad language that said they would dismiss with prejudice all possible counterclaims that they had, knowing not only that they had threatened those, but that they had done something similar in the Encore Technology versus ClearTouch case in state court, where the South Carolina Court of Appeals had to apply res judicata to dismiss a second lawsuit on the eve of trial by ClearTouch. And we handled that case for Encore, so we were trying to negate the possibility of a subsequent lawsuit because we had dealt with that in the past, and they had threatened it in the removal when they attempted to get the state court case to federal court. So that's the best way we found to handle it. And if they wanted to reserve the right to claim that Oker's marks that at that point had been registered with the U.S. Patent and Trademark Office that had been used for 2 years, that ClearTouch had gathered evidence that Oker's was using, if they wanted to reserve that, then they shouldn't have agreed to dismiss all possible counterclaims. They should have agreed to a more limited dismissal language, and they did not.
Do you agree that there's a genuine dispute about whether your client used the marks after settlement, post-settlement?
There is no dispute. There's no dispute that the Oker's company used its TouchView marks after the settlement agreement. We do not dispute that.
I know you have an argument in your brief about whether those were in commerce, but putting that aside, just the use of the mark, you agree there's evidence of that?
Evidence of the Oker's company. Let me be clear, because this sort of goes to their first issue where they attempt to conflate the Oker's company, which was doing business as TouchView Interactive and registered the TouchView mark, with TouchView Interactive Inc., which is a separate shell corporation. And so which we call the TouchView Corporation. The TouchView Corporation never did anything, did not use these marks, and I just wanted to be clear about that. So, but
Oh, I'm sorry, can I ask you a related question? So you go to the jury on your breach of settlement claim and you win. I'm right so far, right? This is a confusing case, yeah. So when the jury finds that the settlement agreement was breached, does that rest on a finding that the settlement agreement actually did preclude suing on continued use of the marks after the settlement agreement was signed? Do you see what I'm saying? How does the jury verdict intersect with what we're talking about now?
yeah, I think the jury verdict said that the settlement agreement was effective, that it hadn't been breached by the Oker's agreement, that it had been breached by ClearTouch, and that breach caused Oker's company damages. I don't think that. How was it breached by ClearTouch? Because I looked at the transcript, and it's a long transcript. You were there. Tell me what constituted the breach? Yes, ma'am. There was a separate provision of the settlement agreement that prohibited ClearTouch from selling products to Pro AV, a competitor.
Okay, so the jury did not find that ClearTouch breached the agreement by bringing the lawsuit.
Correct. That was not the theory of the breach of the contract. It was selling products to Pro AV in 2022 in Massachusetts.
Okay.
So,
but let me get to a question that I think I'm processing Judge Rush's questions to you because it really provokes some serious thought on it. And one of the points I want to see if we are in agreement on, it seems to be some agreement that ClearTouch didn't know about this infringement when they signed the agreement. The question that comes arise when you're dealing with continuing conduct and what the agreement says. The agreement says that you could have brought this as a counterclaim when you had that state court litigation. And then the question arises, well, does a claim keep arising every day? So you couldn't have brought the one that's going to be tomorrow or the one that you're doing now down the road. It reminds me of those kinds. I guess what I'm getting at is statute of limitations is a little different than actually having the actual claim. Because it sort of links in to continuing conduct. But here you got some continuing conduct, but you have an agreement that says you can't bring a claim that you know you can bring right now, and that's infringement. Whether that happens down the road or wherever it is, if you know about it now in the agreement. And so that I think is a question, and I don't know if there are cases on it or not, but it would seem to me to be odd that if unless I've interpreted an agreement as saying not only can't you bring it, but you won't do it anymore. And I don't see that in there. That it's not a question you won't do it anymore. It's just you can't bring it. And if you wanted to put that language in there, it says not only won't bring, but on the other side, you agree you will cease doing this, whatever you're doing. We're focused on the settlement agreement. So the settlement agreement says you can't bring a counterclaim on a matter that you know about now, and it seems to be very clear they knew about the infringement at that time. First of all, what is the evidence that they knew about the infringement? And then answer the question in terms of whether the continuation of it gives rise to new claims that would not be covered by something that says you can't bring it.
Yes, Your Honor. On the first point, the evidence that ClearTouch knew about it is throughout the record. It's Plaintiff's Trial Exhibit 30, which is at the Appendix 121, Defendant's Trial Exhibit 47, which is at JA 124, Plaintiff's Trial Exhibit 43, which is Joint Appendix 133, Plaintiff's Trial Exhibit 13, which is JA 136, and Plaintiff's Trial Exhibit 83, which is JA 200, is the email where they threatened intellectual property counterclaims before this mediation. And I think you make a very important point that we not only have a settlement agreement, but we also have a state court order. And if we only got it because ClearTouch refused to consent to the stipulation with that dismissal of all possible counterclaims in it, I think recognizing the effect that would have. So, and Judge Addy, and we quoted the transcript, recognized what was going on and over ClearTouch's objection, entered a state court order which has independent res judicata effect. Now, in terms of the notion of continuing conduct being precluded by a settlement agreement and the res judicata, we've cited several cases in our brief. The J.M. Smith Corporation versus PCI Corp was a Fourth Circuit. It's an unpublished case, but it involves a settlement agreement. And it said that when that settlement agreement was entered, it dismissed or precluded a subsequent action for the same misappropriation alleged by the plaintiff prior to the settlement agreement. We also cite the District of Maryland, the MAS Associates case that found that res judicata precluded continuing claims. And on this point, if ClearTouch's theory is correct, what that would mean is that they could have gone to trial on these trademark claims that they knew about in 2019 that Oakers had registered, not the ClearTouch mark, but its own mark. We could have won a defense verdict at the jury trial, and then they could bring another case for the continued use of those TouchView marks later. And we could have an ongoing, never-ending series of litigation if ClearTouch's theory is right. And the document
ClearTouch does, they allege willful and intentional conduct of an ongoing infringement. But the question I have is, could that exact complaint have been filed as a counterclaim in the state court litigation?
Absolutely.
It alleges this ongoing treatment. Could that have been done there?
Yes, sir. It absolutely could have. And in fact, that's what Place Exhibit 83 alludes to when they told us that they wanted to be in federal court and when they attempted to remove the state court action because they had federal intellectual property counterclaims. They knew that Oakers had registered the TouchView mark and was using it in commerce. They had collected through those exhibits I cited to you all that evidence that it was ongoing. And to Judge Rushing's point, they had an opportunity in the settlement agreement. If they wanted to limit the future of that use, they could have insisted on that instead of agreeing to dismiss all possible counterclaims.
You know, You've mentioned that you think statute of limitations and when a claim accrues might be a somewhat different question, but this conversation strikes me as what the district court did in Lyons. The district court in Lyons said that trademark infringement was ongoing and a continuous claim, and so it lumped it all together. And we disagreed with that and said, no, each act of infringement is its own claim, and we said each infringement should be considered separately. Each sale or rental should be considered separately under an infringement analysis. And how do I incorporate that understanding of trademark infringement with your theory about what is precluded by the settlement here?
I would say that Lyons was analyzing claims for purposes of the statute of limitation, which is different from a res judicata analysis.
And why is that different? When a claim accrues for a statute of limitations is different from when a claim accrues for whether the claim is could have been brought. Why is that different?
And I think the policy underlying, and again, I'd refer you to Hartnett versus Billman. The reason that the Fourth Circuit has adopted a broader view for res judicata is there needs to be an end to litigation for the parties, for the attorneys, for judicial resources. And so that's why res judicata is not.
But like the question of when a claim accrues also has to do with when you can sue on it. You can't sue until the claim has accrued, until you have a claim, right?
Right.
Which would seem to suggest they didn't have a trademark claim for post-settlement infringement until the post-settlement infringement happened, right? If it didn't accrue till then.
Well, they had claims because Oakers had registered the TouchView marks, had been using the TouchView marks in commerce, and they had claims that they had threatened to bring for trademark infringement prior. It's just that they want to argue that, okay, no matter what happens, even if we have a trial and the jury rules in our favor, we can continue to sue because these claims will continue to arise forever.
Well, I mean, if you have a trial, if a court rules or a jury decides on whether the trademark is infringed, then that becomes res judicata, right? Like maybe a court or a jury decides who actually has the rights to the mark, right? But you don't have that. Instead, you have everyone agreeing. Every disagreement we've had thus far that we could have sued on up until today, we're releasing, we're dismissing, that's the end of it.
I would just conclude by saying both Hartnett versus Billman and J.M. Smith Corporation treat a settlement agreement that leads to an order of dismissal as a res judicata order ruling on the merits, as if we had gone through the jury trial.
I'm sorry, can I have 1 minute, Judge Nguyen?
You may take as much time as you like, Judge Harris.
I think
You
this will
too,
be-
Judge Rushing. You may, Deb, as much as you like today.
This will be reasonably quick. So I'm just trying to sort of get this straight in my head. There's the question of how we think about this for statute of limitations purposes, how we think about it for res judicata purposes. But then, I think there's another layer because we've also said normal res judicata principles, there's an exception when we're talking about a settlement agreement. We don't apply necessarily normal preclusion rules. It all turns on the intent of the parties. And so I feel like for me, the question is when I look, and I think this is where Judge Rushing started really, what did the parties intend? And I think that is separate from the question of what happens under an ordinary statute of limitations question, what happens in an ordinary res judicata question, unless we think the parties intended to incorporate the law of statutes of limitations into this settlement agreement. So I think we just have to look at the settlement agreement. And I guess I think Judge Rushing has raised some questions about, look, if they really intended to say, you can keep using the mark, they didn't put that in. If they really intended to say, we're giving up all of our claims, not only the ones that we have today, but ones that might show up in the future. It doesn't say that expressly. So what is your pitch for, no, this is what the parties intended?
It's because in March, 2 months before the mediation, ClearTouch said that they had federal intellectual property counterclaims. And when we got to the mediation, we did that before they had answered or had an opportunity to assert counterclaims. And so the only way we could really address that is by handwriting that language in that they were agreeing to dismissal with prejudice of all possible counterclaims. And the only way to give that language meaning is to find that it has res judicata effect.
Any further questions, Judge Harris? Judge Rushing? All right, thank you, Mr. English, for your presentation. Mr. Smith, you have a few minutes for rebuttal.
Yes, Your Honor, thank you. I'd like to start by saying there is absolutely no evidence and no way that Oakers can contend the jury did not rely on their theory of liability that ClearTouch filed that lawsuit breached the settlement agreement.
Okay, how does that help you? I'm so baffled as to the parties' positions on this question. If the jury found that the settlement agreement is properly read the way the Ockers company is reading it, then for you to prevail on this point, you have to be able to say, as a matter of law, it is impossible for any reasonable jury to read the agreement that way. So I guess that's your position.
I'm sorry, Your Honor, I didn't quite understand what you said just then.
I also thought that in rendering its verdict in this case, the jury made a finding that this settlement agreement did indeed preclude ClearTouch from suing after the date of the agreement based on continued use, the same use of the same mark going forward. I think that's what the jury found. For you then to prevail, it can't be enough that, it's not 100% obvious that that's what the agreement says. It has to be the case that as a matter of law, no reasonable jury could possibly read the agreement that way. It's a much higher threshold for you now. Did that clarify?
Yes, Your Honor, I appreciate that. Here, I guess my point was more simplistic on this issue, was that there's nothing at all in the record to show that the jury found that ClearTouch violated the settlement agreement by filing this case because they weren't asked. The judge found that before the trial started, then told them that's what the court found. And Ockers, as we've cited in our briefs, utilized that as part of the case presentation. They bookended their opening and closing with this. Their closing said it's a joint exhibit 3872 to 3873, speaking to the jury, telling them to find us liable for filing the case. Judge McDonald told you at the beginning of the case that those claims have been dismissed because ClearTouch filed a lawsuit that the settlement agreement said never should have been filed, end quote. So Ockers utilized this judicially endorsed theory of liability. And essentially, we were having a trial on damages after that, after they were told that the judge determined before trial started that ClearTouch never should have filed this lawsuit in the first place. Then also, the couple of issues brought up in my first 15 minutes, I'll address the best I can in my 2 minutes here. The new versus different evidence, Judge, you're right. We looked at the citation, and it's in a block quote within the res judicata order. It does say different evidence, but again, it goes back to what I said before in response to our discussion on that issue. We very much contend the evidence that the court called new was not different than what had already been submitted in support of summary judgment. And Oakers made a decision not to submit that transcript, the deposition transcript, in support of summary judgment. They went with their own client's characterization of it, which is again more favorable to their res judicata argument. And then the release versus dismissal, the notes I actually had on this were brought up at the end of your discussion with Mr. English, was that it is a different analysis, a different res judicata analysis when you're dealing with a settlement agreement affecting that, as the case law says. So you do have to look to the intent of the parties, as the controlling law says, and that is.
Let me ask you a question about that in terms of how we view settlement agreements. And I seem to think I read this, that, if you got an agreement and then there's a handwritten portion of it, don't you give that handwritten portion more weight than you would ordinarily? I mean, people who write something in their handwriting, you give a lot more weight to that than you do something that's typed in there. Is that not correct?
Yes, sir. That is what the law is. You're absolutely on point there. But you look at, and this is Joint Exhibit 202. This is I call it the Memorandum of Agreement for Mediation, where that handwriting is. It's qualified by the language that precedes it. It is not in isolation. The language that precedes it says the parties release one another of any and all claims brought or which could have been brought, known or unknown, arising out of or relating to the subject matter of this lawsuit. The case is to be dismissed with prejudice. And then this next part's the handwriting, including all possible claims and counterclaims. So the language preceding the handwritten language qualifies it and limits its scope by saying claims and actions arising out of the subject matter of this lawsuit. This lawsuit was the state action brought by Oakers against Clear Touch.
Let me ask you about that. I want to ask you the same question I asked Mr. English. Could you have could Clear Touch brought this same complaint? Could that have been filed in the state litigation as a counterclaim because you alleged it was ongoing infringement?
Not with what Clear Touch knew at the time, Your Honor.
What did you mean by ongoing infringement?
In the complaint?
Yes, it's your language.
I think there's, sorry, I didn't interrupt you.
No, go ahead. I mean, yes, that's what I mean. In the complaint, you said it.
I have to say this, pleading language, and each, as your colleagues pointed out, as we pointed out in our briefs, each separate act of infringement is viewed in isolation. So while that might not have been the most artful language to use, we definitely do not say it was an ongoing tort because there
Let me just ask, why couldn't you have brought this exact complaint in the state court litigation? Why could you not have brought it then?
It's based on what was known at the time, and I'm not sure we could have brought the same action we did bring, and we're just dealing with the parties then, and the claims in the state action the parties wanted to resolve those, and that's what my client wanted to do. So at the time, I think this is part of the record. Mr. Perkins gave some testimony in motion limine hearing. My co-counsel, who's our patent bar admittee in this group we have here, and he testified, I believe, that after settlement agreement and all that, there was investigation conducted, and at the time too, now we know through discovery all the interplay, we think, between TouchView and Oakers, and at the time, none of that was known, none of that was out there. So I don't think the same claims could have been brought.
Okay, let me ask Judge Harris and Judge Russian, give them an opportunity to ask additional questions if either one of you have some. All right, Mr. Smith, I want to thank both of you for your fine arguments today. The court is going to sign off, sign and die for the week. This is our final case of the week. And as we have been repeatedly saying throughout this week, the tradition of this court, we would come down and notwithstanding our vigorous questions or the way in which you might interpret it, we would shake your hands and thank you for being in our court. And we virtually do that right now. Unless either one of the judges think that there's anything further, I'm going to ask the clerk to now dismiss this sign and die. And may you both and everybody on this panel be safe this week for whatever snow or whatever's coming our way. Madam Clerk, would you proceed?
This honorable court stands adjourned, sine die. God save the United States and this honorable court.